Now I'd like to introduce LWV San Diego President, Lori Thiel.
Thank you, Kim. I'd like to take a moment to welcome you all and thank you for attending today. I know we're really busy and it's important to have some time to do events like this, so I appreciate your attendance today. I want to tell you a little bit about the League of Women Voters before I turn it back over to Kim to move forward with the program, because I'd like to provide some voting information for you all. So the League is a 100-year-old organization. We were founded in 1920, so 100 years old this year. We were founded to support women's voting rights. So as you probably well know, 1920 was also the year that the 19th Amendment was ratified. And we wanted to support that new voting bloc of women. Now, of course, over the 100 years since our existence, we have been supporting voters of all genders, ages, ethnicities, and we do a lot of voter registration and voter outreach, etc., particularly at this time of year. So I'd like to provide some information here for you so that you can take advantage of some of the opportunities that we've provided for you this election season. So first, I want to make sure that everyone on this this event is registered to vote. And if you're not sure or you're unaware, you can go to the Secretary of State's website or as registration. I also want to let you know that we have a website, the League of Women Voters of San Diego, that is very robust with voter resources. So you can go to lwvsandiego.org, click on our menu item called Voter Resources, and that will take you to a page that is just full of opportunities to inform yourself on voter information and opportunities to become educated on what's on your ballot this year. You'll also find on our website an opportunity to attend a prop talk. So that is where we review your ballot. Go to our website and you can actually attend one this weekend. We're hosting one on Saturday at 10 a.m. You can register for that on our website under upcoming events, or you can go to our website calendar and go to Saturday and click on registration there. But we also have a list of other prop talks that are available for you. If you are unable to come to Saturdays, we'll record it and post it on our YouTube channel. But you can also go to a series of other prop talks that we've prepared for you as well, and they're live. They'll be on our website as well if you'd like to go check those out under our voter resources opportunities. You can also attend a candidate forum. We interview candidates and we get their opinion and positions on a wide range of topics, and we take questions from attendees. So if you'd like to attend one of those, you can go to our website, click on upcoming events, and you'll see opportunities to attend candidate forums as well. And finally, I'd like to invite you to go to our YouTube channel where we post a lot of our videos like this one, where you can review events that you either didn't have an opportunity to attend, or perhaps you attended and missed something that you'd like to review. You can go to our YouTube channel and you can see those videos. We'll put a lot of these links in the chat for you when I finish my presentation so that you can link to some of these opportunities that I've mentioned for you today. So now I'd like to move forward with our program. I'm delighted to host this important and timely event. This event today is a production of the National Association of Women Judges Informed Voters Fair Judges Project, and that's a nonpartisan voter education initiative developed to educate the public about the constitutional role of the judicial branch and to protect our courts from outside influence. As you all know, the League of Women Voters is a nonpartisan organization as well, and we've enjoyed partnering with this organization in the past over events that are similar to this that provide voting information to our local and regional voters. So with that, I'm going to turn it back over to Kim, and Kim, you can move forward with the program. Thank you all.
Thanks, Lori. Now I'd like to introduce our speakers. First, one of the most distinguished jurists in California, Justice Judith McConnell, Administrative Presiding Justice, Court of Appeal, 4th Appellate District, and member of the National Association of Women Judges and their Informed Voters Project. And Professor Virginia Nelson of University of San Diego School of Law and Fellow of the American College of Trial Lawyers. They are with us to discuss the Constitution, the work of the judicial branch, the importance of fair and impartial courts, and how we evaluate judges. Martha Cox is a San Diego League member, and she'll be monitoring the chat during tonight's event.
All right, hello everyone. The final draft of our Constitution was signed on September 17th, 1787. So we celebrate now Constitution Day on September 17th of every year. Our Constitution is the longest surviving written charter of government. And as the President was indicating to you earlier, this program is a collaboration between the National Association of Women Judges and the American College of Trial Lawyers. Justice McConnell is a leader in the National Association of Women Judges, and I'm a fellow in the American College of Trial Lawyers and co-chair of this national collaboration. So we have joined together because we felt it was so important to further educate the public on our Constitution, on the judicial branch, and on fair and impartial courts. We are very appreciative of all the support that the League of Women Voters has given us to be able to present this program to you tonight. A couple things we need to go over in terms of the outline for the program. We're going to talk about the unique role of the judicial branch in our constitutional design. We're going to distinguish between judges and other important government officials. We're going to evaluate the significance of the judicial branch and the importance of fair and impartial courts. And finally, we're going to explore some of the challenges that face the courts. Some of these challenges you may be aware of, but others may surprise you. We'll go over both categories. Also, a couple ground rules that Justice McConnell and I need to follow. We are nonpartisan, as Lori Thiel said. We cannot discuss pending cases or pending appointments. And finally, a word of appreciation. Everyone who joined this webinar was wonderful in responding to the questions that we asked you in the registration materials. And we will be providing your responses as we go through this presentation. But also you asked questions, a lot of questions, and we will, within the parameters of what we can discuss, we'll also try and answer as many of those questions as we can during the presentation this evening. Now, for a baseline on what do Americans know about the Constitution, this Annenberg Public Policy Center at the University of Pennsylvania has been doing a survey every year for many years to gauge the knowledge of the American public on these issues. And the slide you're looking at is from last year, because this information tends to come out towards the end of September. And at that time, 39% of Americans could name all branches of government. Now, as you can imagine, due to the recent events and the coverage that we have in our country of government functions and the differing branches and the conflicts that exist, this year the results just came out, and now over 50% of Americans are familiar with the three branches of government. And importantly, they're much more aware of the First Amendment and the rights that are contained in the First Amendment. So Justice McConnell and I see that as a positive indication and the way that we want to move further with this collaboration is to move the needle on the knowledge of the public throughout the United States by having our members go out and make these presentations throughout the country. So now we're going to do a bit of a civics refresher. We can all benefit from that. And Justice McConnell is going to take you through some of the questions that are on the U.S. naturalization test, which is the test that people take who are seeking citizenship in the United States. So here we go, Justice McConnell.
All right, so one of the things we've learned from your registration answers to the questions we posed is that you are a very knowledgeable group. So we're going to move somewhat quickly through these. Everyone seemed to know that the Constitution is the supreme law of the land, which is I'm glad people knew that. And I hope you carry your Constitution with you, as I do. It's an important document, and it's helpful to every now and then look at what is actually in it so that you can be reminded of that. Now, what does the Constitution actually do? Well, we know that you know the answer to this as well, because you told us. It's our legal framework for our whole government, and it governs all branches of the government. It defines the governmental agencies, and it protects basic rights of Americans, which is what is most important here.
And let me just interject for a second that in the link that we sent you in the registration, you do have access to the Constitution through that link in case you don't have a pocket Constitution.
That's right. If we were doing this program in person, we would make sure each of you got one. But I know from the chat, that some of the chats we've received, that there are people in this program who carry their constitutions with you, and I'm glad to hear that. Now, what is the rule of law? This is not a simple concept. In fact, the rule of law is something we as judges deal with all the time. First of all, no one is above the law. The law applies to everyone. It applies to citizens and non-citizens. It applies to everyone in our country. And the rule of law is basically a set of principles that guide us. It's the ideals that guide us to ensure an orderly and just society. One of the things that is very important in modern civilization, when you're engaging in business or just personal interactions, is you have certain expectations because we are guided by the rule of law. Everyone is held accountable to the same laws. The same laws apply to everyone, and everyone is treated equally under the law. These are the ideals that we hope to follow, and we know that's not always the case, but it's our ideal. How can our democracy prevent here's an interesting question that we got from one of you, is the president above the law? And of course, the answer is no, everyone has to follow the law. So these rules that we have under the Constitution apply to everyone. We're going to talk about the three branches, but presidential powers are not unlimited because the president is obligated to follow the law, just as judges are obligated to follow the law, lawyers follow the law, and all of you who are watching this program are obligated to follow the law. You want to go on to the next slide? So here's the next question. We found that, you know, if you go out to the public at large, not everybody knows what the three branches of government are, but clearly all of you do. And so what's interesting and what not everybody knows is there are sort of parallel three branches, both at the state and at the federal level. So you know that we have a state constitution, we have a federal constitution. The United States Constitution is the highest law of the land, but in California we have a constitution that also governs us, and we have a court system, we have an executive, in the state it's the governor, and we have a legislature. That's true at the federal level and it's true at the state level. And those rules of law govern us day in and day out. And some of them are more complicated than others. And that's why being a judge is a full-time job, because judge's job, as you'll hear, we're going to talk about it a little bit more, is to interpret and apply the law and hopefully do it in a fair and impartial fashion.
So moving on, why do we have a constitution? This is one of the questions that we ask you. And of course, you all answered the question correctly, very simply, that it's the structural framework for our government. So think of it as a rule book. It outlines the structure and the function of the government. It limits the powers of government. It lists some of our rights, and it reflects principles and values. Justice McConnell was just alluding to the levels of law the hierarchy of laws that we have in the United States, and think of it as a ladder, and we'll go through them together. At the bottom of the ladder are the local ordinances. Above those are the state statutes, those laws that are passed by the legislature. Above that is the state constitution. Above that are the federal statutes and acts. And finally, at the top is the US Constitution, so defined as the supreme law of the land in the Supremacy Clause of the Constitution. So when you're reading or hearing about a local law or a state law or a federal act, you now can think of the hierarchy that works like a ladder to control the authority at each level for each of these rules. And as Justice McConnell was explaining, we have parallel court systems in the United States. First, we have the federal side, which has, as you can tell from the hierarchy of laws, has constitutional laws, federal statutes and acts. And the jurisdiction for the federal court is the legal authority that a court has to hear a case. And so federal courts address issues of federal law primarily, not completely. They certainly have other appended actions, but their primary jurisdiction is for federal law. Then we have that state system, and the state courts address their state law, the state constitution, the state statutes, again, primarily. What's an important fact that about the work of the courts that a lot of people don't know is that 90%, that's 90% of the cases heard are in state courts. And state courts control the process by which judges are selected and their terms. On the federal side, the terms are generally lifetime tenure. So it is a different system in the way the judges are chosen and their lengths of service. Now, the Constitution begins with the Preamble. And the Preamble begins with the keywords, "we the people." So what did "we the people" mean in 1787? It meant something very different than it means today. It meant white males who were wealthy landowners. Now, from that point, those 230 years ago, the definition of "we" has been expanded multiple times. And it's been expanded to include different races, to include another gender, to include the right to vote at 18 instead of 21. And there are literally 20 different modifications to voting rights to support and broaden that most essential right for citizens to vote. So how did that process occur? How did that expansion, those new meanings and definitions come to be? Well, it's an evolution of the process because the judges who are deciding cases throughout time receive the facts of the case and they apply the law. And they look at the structural framework of the Constitution, they look at the statutes and acts, and they looked at the body of the judicial decisions that have come before them. And all of that material informs their decision in the current case. So that's the process and the evolution of the changes that have occurred in the Constitution. Now, the Constitution has three parts. We've talked about the Preamble. There are three branches of government, and then there are amendments to the Constitution. The articles start with the three co-equal branches of government, which are the legislative branch, as you well know, the executive branch and the judicial branch. Importantly, co-equal branches of government. And let's talk for a moment about the amendments. There are 27 amendments to the US Constitution. And I don't know whether that seems like a small number to you or a large number to you, but the reason why there are that many over a period of 233 years is because the amendments to the Constitution have to follow a very rigorous process. They have to go through a 2/3 support by both houses of the legislature and then 3/4 ratification by the states. So that is a significant process to go through. It's not the only way that laws change on the federal side. As I said, we have statutes, federal acts, and judicial decisions. Now, if you contrast that with our California Constitution, there are ways, much more flexibility in the ways that we can amend our California Constitution. So the California Constitution is actually the 8th longest constitution in the world. If you're wondering who's first, I think it's India. So we're going to go to a chat now, which means a chat or the more where Kim told you to go. We'd like you to answer the question, what is the Bill of Rights? You're going to be sending your information in to our League of Women Voters expert, Martha Cox, who will be filling us in on your responses. I wish I could play some music during this period of time, but just go for it.
Folks are thinking.
That's a good thing.
The first 10 amendments.
First 10 amendments. All right. Well, right off the top, it does not surprise us, Justice McConnell and I have great respect for this audience and their abilities. And yes, it is the first 10 amendments to the Bill of Rights. And if you remember at that earlier slide, the Bill of Rights was ratified in 1791. So these first 10 amendments have been around for a long time. So let's go to the second question that we'd like you to respond in the chat. And we'd like you to name one of the rights in the First Amendment, and we'll see if we can get them all. I'm confident we will.
Freedom of speech, rights of the people, right to bear arms, freedom of speech again, religion, speech, association, freedom to assemble, freedom of the press.
Okay, we've got 4 out of the 5. And we'll give a few more seconds to someone. The 4 that are in the First Amendment are speech, press, religion, and assembly. And the right to bear arms is in the Second Amendment. So there's one other.
Right to jury trial, freedom of religion.
Right to jury trial is another amendment, just not in the first one. This is probably the hardest one.
Freedom to protest.
Okay. Well, the 5th right in the First Amendment is
File grievances against the government. Forgive me, Jenny.
perfect timing. Perfect timing.
That's great.
In under the wire. That's wonderful. Okay, so let's see here. Now we're going to move to a topic that's right in Justice McConnell's wheelhouse, distinguishing the judicial branch and safeguarding the Constitution and protecting the rights of the people. Justice McConnell?
Thank you very much. I noticed that one of the respondents mentioned freedom of the press, which I think we all agree is part of the First Amendment. So the question here is, what is it exactly that the judicial branch does? many of you know the answer to that. We resolve disputes. We resolve disputes between private individuals. We resolve disputes between government and private individuals. We handle criminal cases where the government has charged an individual with a crime, and we determine if a law is unconstitutional. Now, one of the things that Virginia mentioned was that the California Constitution is one of the longest constitutions in the world, and we deal with California constitutional issues if they're not applicable, but we also deal with federal constitutional issues in state courts as well as in federal courts. And one of the things that is most unique about the judicial branch is that we have to protect the rights of the people. Whether they come to us with a civil dispute like a contract dispute or a property dispute or a family law dispute, probate matter, we have to protect the rights of the people to a fair and impartial decision-making process. And we know that all of you have a pretty good grasp of what the courts are all about. We resolve disputes through a legal process. What's interesting here is keep in mind, we don't reach out to the community and say, we're going to decide this issue. We decide cases that are brought to the court. So somebody files a case in the courts, and if you know anything about the courts, people file cases all the time at all different levels. And so the cases come to us through the citizens or through governmental agencies or private organizations or any kind of way, cases filed in the court. And we have to decide those cases. Now, what's interesting is in many, many cases, it is you, the jury, that decides the case. You decide the facts of a particular dispute. The case comes before us and one side says, this is what happened. And the other side says, no, that's not what happened. It was this that happened. And that kind of issue can be decided by a jury. And if you haven't ever served on a jury, I can assure you it is one of the most interesting experiences you can have. And I urge you, when we get jury trials back up and running, which will happen shortly in San Diego, if you are summoned and it's safe for you to do so, I urge you to show up for jury duty and hope that you will be called. I actually had the pleasure of being on a jury myself some years ago, and I thought it was one of the most interesting experiences I'd ever had. Now, what happens with a jury, though, is they don't have unfettered discretion to decide the cases. They decide the facts, but they have to decide the facts according to the law given to them by the judge. And in a criminal case, the jury decides whether someone is guilty or not guilty, and they do that by following the instructions. They apply the instructions to the facts that they have found, and that's the role of a jury. Now, sometimes there's a dispute between individuals that ends up in a criminal court. And that's where the city attorney or the district attorney or the attorney general, those are our prosecutorial agencies in state court. In federal court, it's the US attorney. They bring the criminal cases. If it's a criminal case, it's brought by the government. The only way a private individual can bring a criminal case is by bringing it to the attention of the authorities and asking them to bring a criminal case. Private individuals do not have the authority to charge someone with a criminal case. So what makes judges different from other branches of government? Well, first of all, you read the Constitution, you know that the legislature is set up to pass laws, and they put together a budget. They have to put together a budget. The executive can veto those laws, both in the state and the federal level. And executive is charged with carrying out the laws. Then what makes the legislative and executive branches so different from the judicial branch? The judicial branch is supposed to be fair and impartial. We don't expect that of our legislative and executive branches. We have people who go and work on them. They're lobbyists. If you've ever been up to Sacramento, sometimes you get on an airplane, it's full of people with t-shirts, matching t-shirts, and they're up there to lobby on behalf of their organization. And they meet with the legislators, they meet with the governor, and that's how they hope to get their legislation passed or maybe prohibited something. And so the judicial branch is quite different. We are not supposed to be subject to that kind of special interest group. We are not supposed to be subject to pressure, political pressure. We are not supposed to be influenced by public opinion or, frankly, by our own personal opinion. We have to follow the law. We have to apply the law to the facts that are presented to us and make a decision accordingly. And so that makes the judicial branch quite different from the other branches, because we're what we call is anti-majoritarian. It's not majority rule when it comes to a court system. Nobody pays us, gives contributions to us to get us to rule a certain way. That would be illegal, and it would be unethical for us to do that. And we're not supposed to also, this is what's very tricky, we're not supposed to be deciding cases based on our own personal views or feelings about a case. What we do is we take an oath of office. We don't represent people. That's an interesting difference. The legislators represent people. We have different political parties, both in the legislature and in the executive branch, and they represent the interests of those parties and the people who support them. And that's what they're supposed to do. That's what people vote for them to do. And with the judicial branch, it's quite different, because we are not supposed to be responsive to special interests or dark money or PACs. We can't do that. Our decisions have to be based on the law. So those are big differences between the judicial branch and the other branches. Judges are supposed to make the decisions based on the law, based on prior decisions. We have to follow what higher courts have said, dealing with similar issues. We have to follow, of course, the United States and the state constitution. And the whole idea of the judicial branch is to be insulated from politics. We are supposed to be insulated from the kinds of pressures that are applied to legislators and to the executive branch. And so how is it that judges go about making decisions, or how should they make decisions? Let's put it that way. So the important thing about, and I think this is what everybody wants, they want judges to be fair and impartial. And somebody's asked, do I feel insulated as a judge from politics? And the answer is yes, I do feel insulated as a judge from politics. Now, we'll talk a little bit later on about judicial elections, because in California, as in 37 other states, state court judges are subject to the election process. And we're going to talk about that a little bit. But the question is, how is it that you keep judges insulated from political pressures? And how do you keep them from so that they are fair and impartial? What kinds of protections are in place to guard against biases, for example? And how do we ensure that judges follow the law? How do we hold them accountable? And how do we get judges in the first place who are going to be impartial? And I want to add something. If you ask somebody who is a judge or who wants to be a judge, how they will rule on a certain issue, and they give you an answer, that is not a good judge. Judges are not supposed to indicate how they're going to rule on a particular issue or a particular case. If they do that, they are being unethical, and we are governed by codes of ethics. And so how do we keep judges accountable? Well, first of all, every judge at every level has to take an oath of office. The oath of office is pretty simple. The judge swears to uphold follow the law, to uphold the Constitution of the United States, to follow the Constitution of the state of California for a state court judge. And so the oath is really critical. What you do is you are reviewed. I mean, if you take an oath of office, we're kept accountable. We're kept accountable by the oath. We have to state the basis for our decisions. There is a process to review our decisions. If you're a trial court judge, there's one judge deciding the case. And if the parties who appeared in that case, whether it's a criminal case or a civil case, if they feel the case was wrongly decided, they can get review from a court of appeal. That's what's shown here as the appellate process. That's where I sit right now, is the Court of Appeal. It's such a different process than in trial court. I can tell you, in the trial court, a judge is faced with a huge amount of cases every day, making decisions on a minute-by-minute basis, tough cases, tough calls. And for us on the Court of Appeal, we decide cases 3 judges at a time in the intermediate appellate courts. And this is true in the state as well as in the federal process. So it's we decide it based on the record in the trial court. We decide it based on the testimony of the witnesses that was presented to the trial court, and we follow the law. We apply the law. And if there was error, that was prejudicial error, then we send the case back, we reverse it. That's one of the interesting things people don't understand. Sometimes there will be mistakes made in the trial court. Error in admitting evidence, for example, some kind of minor error. We only reverse a case if there is prejudicial error. In other words, it affected the outcome of the case. Judges have to follow also a code of conduct. It's a canon of ethics, and it applies to all judges. And we have to be very careful not to hear cases on which we're disqualified. We have to be fair and impartial. We can't be racist. We can't be sexist. There are all kinds of rules that we have to follow in our code of conduct. Actually, we're not supposed to engage in political activities. So a lot of judges, when they retire, say they've suddenly got their First Amendment rights back, because we don't have First Amendment rights as judges. We're not supposed to go out and campaign, for example, for somebody or support somebody. Another way judges are held accountable is by disciplinary actions. And in California, we have something called the Commission on Judicial Performance. And the Commission on Judicial Performance is an independent constitutional entity. Majority of the members are not lawyers or judges. They are public members and citizens appointed by various authorities. And there are judges on it. There are 3 judges, 6 public members, and 2 lawyer members. And they discipline judges for violation of codes of conduct. I served on that for 8 years, and it was a most interesting process. And I think it's another way to hold judges accountable. Now, there's one other thing that's not listed up here that is another way to hold judges accountable, and that's and by the way, for federal judges, the disciplinary action is impeachment. They have a life tenure. So if you want to have if a federal judge behaves inappropriately and after being informed of their inappropriate behavior hasn't resigned, then the appropriate action is impeachment. And that does happen from time to time, not very often. It's usually when the federal judge has committed a crime, they are impeached by Congress and removed from their judicial position. But another way that judges are held accountable, and we're talking about this tonight, is elections. This year, at this time, we only have one judicial office on the ballot in San Diego County. There were more earlier on, but they were decided in the primary. And there's no sitting judge that's currently being challenged. But a sitting judge can be challenged. If you're a trial court judge, a sitting judge can be challenged. Somebody can run against them and say, this is a bad judge, or they've behaved inappropriately. And the Disciplinary Conduct Commission didn't remove them, so we're going to remove them. And voters have the right to do that. And it's true that we don't have many judges on the ballot right now, but every year that the governor is on the ballot, which is every 4 years, the courts of appeal and the Supreme Court of California are on the ballot. Not all at once. It rotates because of the terms of office, but the terms of office are up, they're on the ballot, and they have to be elected in a general election. It's just a retention election. So nobody can run against a Supreme Court justice or a Court of Appeal justice, but people can remove them by not retaining them. Somebody has asked, why are federal judges given lifetime appointments? And I'd like to add, it's not just federal judges. Some state court judges have lifetime appointments too. And I believe if you read the Federalist Papers, the reason they gave lifetime appointments to the judges is so that they would not be subject to whims of the time, so that they would not be, so it would be insulate them even more from political pressure. And there are examples of that too. By the way, I remember many years ago, one of the California Supreme Court justices said, the alligator in the bathtub is the voter, because California Supreme Court judges are on the ballot every 12 years. And in fact, some of you may remember we had 3 judges removed from office by the voters. So that is the alligator in the bathtub. And if you're a federal judge, that alligator is not in the bathtub. It must be somewhere else. It's an impeachment. It would only be an impeachable offense that would get you removed from office. So one of the things that is important to remember, however, is that even when a judge is on the ballot, judges cannot promise to rule a certain way on any case or to have a policy with regard to handling certain cases.
Okay, we're going to switch gears a little bit to another topic that we want to address: courts and politics and incompatible values. I'd like you to again participate in the chat, starting with identifying one or more positive labels that you have heard used to describe judges or judicial decisions. And Martha, you can just call them out as you hear them, as we did in the last one.
Okay.
Positive, not negative, positive. Let's start with positive.
We'll get to negative.
Fair. Good. Fair, honorable, impartial, just, honest and intelligent, fair and just, landmark, fair, integrity, impartial, positive. She really knows the law. She's fair and impartial, honest. Great.
That's good.
Courageous.
Okay.
And that's from Sue, who always carries her Constitution with her. Thank you, Sue.
Excellent. Okay, let's switch to more on the negative side of things. fill the chat with negative labels that you have heard used to describe judges or judicial decisions.
Biased, bias, unequitable, activist, predictable, indecisive, one-sided, narrow-minded, biased, confused, activist, negative, already has her mind made up, doesn't seem to listen to all of the testimony.
Okay,
I think
so,
we reached it. Yeah.
okay,
Boasts of leaning conservative or liberal.
right. So we also came up with some labels, and they're very similar to the ones that Martha was calling out from all of you. Obviously, our goal is to have judges be fair and impartial, to be ethical, to be nonpartisan, to be unbiased, to be professional. It's when and labels, you know, you don't commonly see judges labeled that way when it's something like that added to their name. Those are certainly the qualities that we want to see in the judges that we support. What we see more of now are labels on the negative side, whether it be in the press or in the media in some way, which attaches labels that are subjective and in the eye of the writer or the speaker, and attached to the judge in a way that is, again, subjective and based upon the viewpoint of the person who's giving the label. And labels like that don't help in any way. Someone asked the question of whether we should pay attention to party labels on judges who are running for office or seeking re-election. And the first important point in response to that question is, in California, we have nonpartisan elections. So when you look at a judicial candidate, their party is not identified. However, as Justice McConnell has said, there are 38 states that have elections, and there are states that have partisan labels attached to those elections. But our strong recommendation is that those labels be ignored. You should not be choosing a judge because they are from the Republican Party or the Democratic Party or independent or green, whatever, because that is implying in that label the assumption that they are going to be deciding cases based upon a party platform. And that's not the way to decide why or what judges to pick. We also see commonly indications of who appointed a particular judge, as if that answers the question of why they ruled the way they did. And if they're doing their job, it has nothing to do with the person who appointed him. It's a completely separate issue. So let's see here. Let's go to the more positive aspect of this issue is, how do we help you identify good judicial candidates and understand the process? And we have a lot of good ideas for you. We have provided characteristics there that are important. But at this time, I want to go into the resources that we're going to be giving you, which assist you with decisions in this area as well as other areas of the vote in a nonpartisan, non-ideologic way. After our seminar is over, you'll get a survey from the League of Women Voters, and you'll also get a resource sheet entitled Resources for More Information. And the first item link that I want to alert you to is something called Evaluating Judges, the Trial Court Handout. This is another superb publication from the NAWJ Informed Voters Project. It's a 2-page document, and they address how should you judge a judicial candidate. Now, this handout is a national handout, so it's not specific to California, which I'll get to, but they talk about how should you make the decision. They go through criteria like we have listed in front of you. and they identify potential resources that you could go to research more fully on the judicial candidates. They also in this document have the website for the IVP overall. So in case you want that link, that's in that handout. Then secondly, there's a link in this resource material to the San Diego County Bar Association Judicial Voting Guide. Now, that's important because for the last 40 years, the state bar, the county bar has identified a group of diverse people from the legal community who get together and do a very labor-intensive research about each of the people who are vying for candidacy for a judicial position. They look at 15 different characteristics and evaluate them. And I encourage you to read those characteristics in the document to inform you about what are the most important criteria for judges. They have an objective system to evaluate them, and then they reach evaluation decisions, and they can be not qualified, qualified, well qualified, or exceptionally well qualified. And all the information, the rankings, ratings of the two judges that exist in San Diego, or two judicial candidates in San Diego, their ratings and all the information about how the county bar came through that process is in that link. And the third resource that I want to provide to you that is a wonderful resource from the League of Women Voters, it's called votersedge.com. Now I'm broadening the import of the resource here. This website is so slick. You go to the website, you put in your residence address, your zip code, and you ask for a ballot, and it pops up a ballot that is custom built for you where you live with the voting decisions that you will make. And that's just the beginning. This resource has the ballot statements of the candidates, explanations of the propositions, who is endorsing each sides of the proposition, who is financing the different propositions. So this is a very expansive opportunity to become as informed as you possibly can as a voter. So those are the three key resources that I want to highlight out of the resource information sheet that we'll be sending you. Further, as an example, when we had more judicial candidates running for office in the primaries, the Union Tribune interviewed all of them and published the interviews. So if you want to find out more about the final two candidates, you can search for the judicial candidate interviews, and you can read what they had to say in January about the process. Also, many media sources provide their opinions or their endorsements about candidates in all areas as well as propositions. We're not suggesting you follow any particular site at all, but it's another avenue for you to get more information to become as informed as you possibly can be. Another option locally is to talk to people in the profession. If you know lawyers, ask them about the candidates or what they think. Again, you may form a different opinion, but it's a way to get information about the judges. Someone had asked how you find out about judges' decision-making, their past decisions. There's no particular sorting of judicial decisions by judges. We have a couple suggestions there. One is that you can Google a judge to see if there's been reporting of a case or decision where there's been any issue of bias or disciplinary action or anything involving that judge just in the media.
Just be careful with that, because some people get obsessed with a particular judge, and you'll see some things on Google that are kind of surprising.
Hopefully you'll sense that when you look at the information. But the Commission on Judicial Performance is a resource to find out if a judge has been publicly disciplined. And for the appellate courts and Supreme Courts, if you're ever in that election and want to know more, they have published decisions that are available on the internet. So there are ways to get more deeply into that information. And also, we were asked, under what circumstances does a judge have to inform of monies that they've received, whether it be a campaign contribution or monies for some other reason. And I can provide you two answers in that regard. There is a Code of Civil Procedure section which requires a judge who has received $1,500 or more, that's 1,500 or more, in the last 6 years from a party or an attorney who's appearing in front of that judge. That judge must disqualify themselves unless the other side knows that and still wants to proceed, but that would be a rare circumstance. So there is a disqualification circumstance, and then there is a canon of ethics which requires judges to disclose $100 and above received from a party, a lawyer, or a law firm. Now that's a duty to disclose. It's not a duty to disqualify. But as Justice McConnell was talking about judicial ethics earlier, there are canons that guide the conduct of judges and require them under important circumstances to let the people in front of them know. And if they haven't reported the contribution or fail to notify people, they can be subject to disciplinary action for that as well. So that's an important protection. So moving on.
So there's a question about the Commission on Judicial Performance. That is a California entity. It's under the California Constitution, but all 50 states have equivalent commissions on judicial performance. They may be called something different, but each state has its own disciplinary body. Okay, so we're going to talk a little bit more about judges and the difference between the judge, again, and other elected offices. And that is oftentimes we have to make unpopular decisions. And that's, if you Google us, you'll see some of our decisions are not very popular. And I remember one case I heard many years ago where it was an environmental lawsuit of some sort involving Orange County, and half the community loved me and the other half hated me because it had to do with where an airport was going to be located. We make unpopular decisions. They may be popular with somebody. Every side has, there's always at least two sides, but you look back in our history, Brown versus Board of Education was a huge decision that came out of our Supreme Court. We all have great respect for that decision, but at the time, enforcing that decision that provided that racially segregated schools could not continue to exist, required the president to call out the National Guard to enforce Brown versus Board of Education, and many other decisions that may have been unpopular at the time, but the court had to follow the law. Now, this slide shows that one of the things that we do as judges is we do not follow the majority. Now, it may be that what we do in a decision is popular with the majority, but that's not our job. Our job is to protect the minority from abuse by the majority. And even though the majority has passed a law, for example, that says people of a certain race can't live in a certain part of the community, that would be illegal, and the courts would have to protect the minority that was excluded from that part of the community. Some rights are so fundamental that the majority cannot take those rights away from the individual. And that's really what makes the courts unique, is that we are here to protect. Obviously, most cases don't involve constitutional issues. Most of them are just a dispute of some sort or a straightforward criminal case. But it is true that we are obligated to protect the minority, and that's our job. It makes us unpopular from times. We weren't designed, we've already handled that one.
Yeah. Go ahead.
Have you gone back?
No, this is, we went.
Oh, here we go. Here we go. So what would happen if judges did decide cases based solely on public opinion or special interest? Well, then we wouldn't have fair and impartial courts, would we? We wouldn't be able to say that the courts are there to protect the minority. We have the rule of law. So how do we feel about that? Martha, are people going to respond to that? What would happen if judges decide a case based solely on public opinion?
I'm ready to hear. Unsafe. The opinions would be overthrown as the ebb and flow of society changed. Really unstable. Women and blacks couldn't vote. Sounds concerning and would make the courts no different than politics.
Right.
But isn't that what happened in housing discrimination?
Well, housing discrimination, actually, there was an initiative some years ago to reinstate housing discrimination, and the courts ruled it unconstitutional. So that's what courts are for, is to protect against acts of the majority that unfairly target a minority.
A couple of more comments here, sorry to interrupt. Judicial branch would become a tool for those who are in power, challenge and disrupt judicial precedent, but ruling didn't translate into practice. I think I picked up another ongoing comment there. So.
Well, good. So one of the things that we try to say is that judges should not be politicians. It's hard to say that with a straight face sometimes. But the Chief Justice has spoken out pretty strongly in this, that judges are not politicians, even when they come to the bench by way of the ballot. And in fact, the United States Supreme Court reversed a state Supreme Court case once because the elected justice of the Supreme Court voted in favor of someone who'd given him $3 million as a contribution, and the United States Supreme Court said that is unconstitutional. That violates due process of law. So the state, as well as the feds, hope that judges will apply the law without fear or favor. And what's been interesting to me, and both Professor Nelson and I have been involved in judicial selection process, is that it doesn't really matter who appoints a particular judge, as long as they take the oath seriously and agree to follow the law.
I'm going to move to the video now and see if it, here we go.
Judges play an important role in our legal system. They decide issues that touch every aspect of our lives. Yet when voting for state court judges, millions of people leave the ballot blank. Polls show voters lack information to make decisions about judicial candidates. We want to change that. States have different methods of choosing judges, detailed in state laws and constitutions. But no matter how your state selects judges, there are some things you should know. Judges are not politicians, even when they come to the bench by way of the ballot. The public expects judges will decide cases based on the facts and the law and not be swayed by public opinion, special interest groups, or political influences. More than 90% of legal problems are handled in our state courts. Nearly 30,000 state court judges hear almost 100 million criminal and civil cases each year. In many states, people vote for judges in either partisan or nonpartisan contested elections. In other states, judges are appointed. Some states also have a separate judicial nominating commission to review applicants who apply to serve as a judge. The commission generally recommends the most qualified candidates to the governor for appointment. This merit selection process can be used for trial and appellate court judges. After the appointment, most judges or justices still appear on the ballot after a specific time. This process, known as merit retention, provides the public with the opportunity to vote yes or no to keep or remove an individual judge. Judges and judicial candidates must follow a code of conduct. They should not make promises about how they would rule in cases before the court. Judges can also be disciplined or removed from the bench for ethical violations. Additionally, judicial decisions can usually be appealed to a higher court. Many resources are available to help you learn about the judges and judicial candidates who may appear on the ballot. Bar associations often post bios on their websites. Judicial forums to meet judges and judicial candidates are often held locally. You can also watch appellate court proceedings on court websites in many states. Additional nonpartisan educational resources can be found at the National Association of Women Judges Informed Voters Fair Judges website. Judges make important decisions every day that may directly affect your life, your family, and your property. So learn more about the judicial branch and the judges on the ballot in your state. Don't leave the ballot blank. Your vote is important to ensure fair and impartial courts. This message is provided by the National Association of Women Judges Informed Voters Fair Judges Project. For more information, go to www.ivp.nawj.org.
Justice McConnell, I'm going to take you to the, since those were covered in the video, I'm going to take you to this final issue of other issues impacting the judicial branch.
Let me get there, get my notes here. So one of the things that has happened over the years is, and you've probably paid attention to this in the press, different legislative attempts have been made to punish judges. In California, there was a term limit initiative many years ago. The Supreme Court of California upheld term limits for the state legislature. And that initiative also included a cut to the state legislators' staff budget. The legislature turned around and cut the Supreme Court budget by 2/3. Although they backed off from that later on. But there are legislative attempts almost constantly to cut back on the power of the courts, to limit the role. And in Kansas, for example, their education system is deeply underfunded, and the battle between the legislature and the Supreme Court has been quite intense. There was something in South Dakota or North Dakota called jail for judges, that if you didn't like a judge's ruling, you could take them to jail. And in fact, I remember the US Congress tried to do that once. They were going to have the US Marshals arrest judges for unpopular decisions and take them before the Congress. So there are attempts by the legislature to control and limit judges and to limit the independence of the judges. And fortunately, they rarely succeed. So here we are with our hero. Of course, Ruth Bader Ginsburg was the second woman on the Supreme Court. The first woman was Sandra Day O'Connor, who is still alive, but retired. And as she says, she is anxious about the state of the judiciary in America. And she has been very active in pushing for better civic education to improve the understanding that citizens have of their government and of the judicial branch, and to try to limit political interference with the judiciary. We mourn her retirement. We mourn the loss of Ruth Bader Ginsburg. And we just have to trust that our judges will uphold the oaths that they take to uphold the Constitution.
So as we come to the end of the program, what can you do? Well, exactly what you're doing now. You're attending a program like this to find out more from us, but also to find out additional ways you can find resources to be the most informed voter you can be. And we have provided information that will allow you to look at areas in addition to judicial ballots to allow yourself to gain confidence in all the areas that you'll be voting on November 3rd. And remember that the candidates that you support for legislative or executive positions, that they support the idea of fair and impartial judges and the role they play in our democracy. As you saw from what Justice McConnell was just talking about, there are members of legislatures who do not support that concept and are actively trying to limit it or get rid of it. So we all have an obligation to find out as much as we can about the candidates who participate in the judicial selection or appointment process. The NAWJ leadership on the Judicial Independence Committee contains 3 justices from Supreme Courts, 1 from Washington, 1 from North Carolina, 1 from California, as well as the Education Chair, Annette Boyd-Pitts, and Attorney Linda Lieli. This is a collaboration that has been extremely beneficial to both organizations. As I said earlier, Informed Voters, Fair Judges has a website which is included in your materials should you wish to go there for additional help. And finally, the American College of Trial Lawyers is, as we said before, very supportive of this project. It's the first time they've ever gone into the public education field, and they're delighted to work with NAWJ because of the fine quality of their materials and because of their passion about the project. So I'm going to stop the share here and just say finally that it was an honor for us to speak with all of you this evening, to hear from you in the chat. And I want to thank the League of Women Voters because they have been past, present, and future. They've been supportive of our efforts, are going to support the after work that's done to support this presentation. And finally, to my co-panelist, Justice McConnell, you are very lucky tonight to have heard from such an experienced, smart, committed judge to doing the right thing and to getting out in the community and talking to people about these issues. And you often, many people don't have opportunities to hear from the judges and hear why the concepts of the oath and the activities of looking at the facts and applying it to the law are what's critical in insulating themselves from political influences. So Justice McConnell spends an extraordinary amount of time doing this, and I really appreciate her efforts. And from my perspective, I say have a good evening and stay safe. Thank you.
Thank you all. Thank you to our panelists and thanks to our attendees. And we hope that you found some mini nuggets of information that you could use to help you with your ballot and moving forward, help defend